Welcome to the Probate Nation. When somebody passes away and has been buried with dignity, the family then typically turns to the process of settling up the decedent's financial affairs and in the due course, distributing the assets left behind. This process is referred to as probate. The first phone call you make is not to the Ghostbusters hotline. Rather, the call should be to set up a consultation, either with the attorney who prepared the decedent's estate documents or, if there are no estate documents, with the probate attorney. This professional can dispel rumors and answer questions about the process and set up a schedule of to-dos and task assignments to probate the decedent's estate. Over the course of a three-part series, we're going to walk through the normal initial probate consult process, which includes identifying what assets need to be probated, who are the beneficiaries of the assets being probated, and who is in charge of handling all the details of probate. Tonight we begin with the typical probate consultation by discussing the typical non-probate and probate assets. Joining me for this consultation is my law partner, David Nur. His practice focuses on estate planning, probate, and the estate and trust administration for clients. David, welcome.
Thanks for having me, Richard.
Well, my pleasure. Thanks for taking time off to come in.
Yeah.
And talk with everybody. So let's just start off, and I gave kind of a brief overview, but tell me, big picture, what's probate all about?
Well, probate is the process of transferring the decedent's ownership in their assets to their beneficiaries. So we're talking about real estate, bank accounts, brokerage accounts, their various tangible personal property. And so we're seeing how it's supposed to pass and who it's supposed to pass to. Now, anybody who's been through probate can attest to it being expensive, long, and time-consuming.
So what are the typical, what are we looking for when we say probate assets? What are we looking for? What are we talking about there?
So probate assets can be any asset that's titled in the decedent's name. So it can be bank accounts, brokerage accounts, real estate, all the things I just listed. But what we're looking to is how is that asset owned upon the death of the decedent?
Okay.
So now that we talked about some probate assets, how do you go about finding what the decedent has when they die?
That probably, David, is one of the most challenging things many times. You go and take a look at good places to look are tax returns. We'll tell you about dividends and bank accounts and other investment assets that might be out there. Might also tell you about retirement accounts that are paying some minimum required distributions. If you don't have a lot of luck with that, you can also, and frequently we have to do this, is you write to the IRS and ask them for a copy of, transcripts that show what kind of W-9s, 1099s that the decedent had. The problem with that particular approach, unfortunately, is that the IRS is not always responsive very quickly. Okay, so you can be sitting around waiting for a while to get some information. Now, the other place to go to as well is if there's an attorney that prepared the documents at the beginning, they may have collected a bunch of information and scanned in bank account statements and stuff like that might also help us to identify, assets you have. But let's talk about when we talk about bank accounts, David, what are we talking about there? What are we focusing on?
So we're talking about kind of the basic accounts that most people are familiar with. So checking accounts, savings accounts, money market accounts, and then also sometimes if somebody was a member of a credit union, we could be talking about various accounts they have there, including a membership account they have with a credit union. Okay.
What about, and again, we talked about I know you mentioned this before, about title really matters, and that's really the important thing is how is it owned? That's what we're really focusing on as we go through each one of these assets, beginning with bank accounts.
That's
right. Is it in just the name of the decedent? One of the things. Go ahead.
Sorry, Richard. So on that, what bank accounts would pass through probate?
Well, typically, those are going to be the accounts that are just in the name of the decedent. So it's in his or her only name. Okay, there's no POD, payable on death designation. There's no transfer on death designation, which we talked about before. Those types of things would pass outside of probate. The other thing would be is if it's joint count with the right of survivorship, those are things that typically would not go through probate. But if there is no survivorship, then it goes through probate. So a lot of times you got to take a look at the actual bank form to see how they set it up. But David, what about if there's a power of attorney that's listed? A lot of times you see these bank accounts that says, John Doe and then POA to Jane Doe. Okay, does that have any bearing on probate?
Has no bearing on probate, because once somebody passes away, any power of attorney on the account is terminated.
So POA means power of attorney?
That's right.
Okay, that was good to know. Now you mentioned membership accounts about credit unions. I know that's an issue that a lot of people don't realize. It might very well be that various other accounts at a credit union have different ownership issues, but the membership account typically has to be in the name of the decedent.
That's correct.
But a lot of times that's for a de minimis dollar amount. It might be $10 or $50 or $100, so it doesn't really pose a lot of problems.
I have a question for you, Richard.
Yeah.
Any concerns with going off what a bank statement may say as far as what title is on the account?
That is a concern, because it's funny you should say that. We've seen a number of situations where the bank account doesn't disclose that something is owned jointly with somebody necessarily, or doesn't disclose that there's a payable on death designation or a transfer on death designation. So you have to be careful, okay? And we'll come back to that as we talk more about this as we get towards closer to getting somebody qualified. That becomes important, that we don't want to assume anything when we start that. Well, let's talk about investment accounts. What about investment, like brokerage accounts? And these are non-retirement accounts. So what are we talking about here?
Yeah, so I think you said something key there. I think the key is that we're not talking about retirement accounts. So we're not talking about IRAs or Roth IRAs. Common here in the area that we live in, Northern Virginia, a lot of people are government employees, so they might have something called a thrift savings plan account. We're not talking about those accounts. What we're talking about is non-qualified accounts, sometimes called brokerage accounts.
Okay. So I think the thing there is these will be stocks, bonds, annuities, and stuff like that are not retirement accounts. And as I mentioned at the outset, the way I think you really figure out whether those the decedent had any of those, the best place I think is the tax return.
Yep, absolutely.
But otherwise, there may be statements that you have been accumulating at the house. Those are also very helpful as well. But a lot of times those statements, David, might very well have, and we've seen that, the brokerage statements may very well have a beneficiary actually listed directly on the statement. I've seen that with a couple recently, and we've called it into question about that was incorrect, and that was an older statement which they had just updated. So,
what would you say, Richard, are we really looking for when we look at these statements? Again, it's similar to with the bank accounts. What are we looking for when we get these statements? We're
trying to figure out how the account is, the brokerage account, investment account, or the stock is actually held. Is it held in the name of the decedent alone? Again, we're trying to corral the assets and kind of begin to separate those that actually don't transfer on death automatically, and then from those that do. Okay, and so that's where we start to talk about probate assets versus those assets that don't require probate. Now, we also see a lot of stock certificates. I've seen where we've come across someone who has, the older clients will actually have the physical stock certificate. They may have 20, 30, 40 stock certificates because that's what they got back then.
I think we've all seen these. I think a lot of times when these companies that have issued loose stock certificates, a lot of times now they'll do it through a transfer agent like Computer Share.
Okay.
So maybe the decedent will be getting these Computer Share statements that are talking about these kind of loose stock. They can be a little problematic when it comes to probate.
Sure.
So if it's in the decedent's name, it's part of their probate assets, therefore it has to go through probate. And sometimes what's necessary with those loose stock certificates is to reach out to Computer Share and kind of go through their directions as far as what they want to see.
Okay. Okay. What are some of the other assets we need to talk about as we sort of work our way through this?
One of the things we should probably talk about is real estate. I mean, that's a big one. If somebody has a piece of real estate in their estate when they die,
sure.
that can lead to a lot of different things they have to do.
Sure. So I think one of the things that first with real estate, one of the things that we would first look at, especially here locally, is if they have a copy of a recorded deed, we'll be happy to see that. But frequently we're sitting in our conference room and you just open up the tax department records and take a look and see what they show there. And that will often get us started especially if you can see when the property was acquired. It may coincide with when they first bought it.
Right, because you can see a sales history oftentimes in the property tax records.
Right. And of course, understanding ownership with real estate is especially unique from all the other assets because of some special things that take place. So, before we get to that, tell me the types of ownership that we might very well see with real estate.
So there's a few common ones. I would say, it might be in the decedent's name solely, and that one's pretty straightforward. If the decedent was married, you might see two types of ownership. The most common one for married couples is a type of ownership called tenants by the entirety. Another one, when you have two joint owners, there could be something called joint ownership with right of survivorship. So with both T&E, tenants by the entirety, and with joint with right of survivorship ownership, the survivorship component in that means that the property will automatically pass to the survivor of the two owners. So that's an important ingredient there. Another common type of ownership is called tenants in common. That's one that means that the interest when the decedent passed away will stay in as their probate asset. So if you have two owners that own a piece of property as tenants in common, and one of the owners passes away, that person's half interest in the property will become part of their estate. And then finally, there's a will substitute called a transfer on death deed that's sometimes used that we'll discuss a little bit later.
Okay. What's one of the things as far as ownership, though, when somebody does pass away and owning real estate, okay, is there anything special that we have to do in order to transfer ownership, or does ownership transfer automatically, at least for that part that is owned by the decedent?
So it's often said in Virginia that ownership of real estate drops like a rock. And what they mean by that is that sometimes there isn't really much that has to be done as far as passing the ownership. It doesn't mean it's not worthwhile to reflect that in the land records so people can see how ownership is passed when they do a title search on the property. But the actual ownership of the decedent's interest in that property drops as soon as they pass away.
So, and I think this is important. For that tenants in common property, okay, that person owns 50% of a piece of real estate. When they die, that piece of property, that interest passes directly to either their heirs at law or their heirs pursuant to their will, and there's nothing else that needs to be done other than maybe some filings with the probate office just to get the land records straight.
That's right.
So you got to be careful about that.
I have a question. So what are some possible issues that can be, come out of real estate that need to be discussed at an early stage? Like if you were in this initial probate consultation with the client, what are some really early kind of warnings that you may provide to them in that consultation?
Some of the concerns that come up immediately is having us understand as soon as possibly can who actually is going to inherit the real estate, either because of the fact that it passed automatically by virtue of joint ownership, or it passed pursuant to a will or by intestate succession, and it's now owned by one or two or three different people. First thing that comes to mind is it currently insured in case it burns down?
Yeah.
That is a big issue, and frequently the insurance coverage that you have on that property, as a residence, as a personal residence, may still continue in force for a short period of time, but you need to find out that answer to that question pretty quickly, because if it doesn't, you need to get substitute insurance. And the question is, who's going to pay for that?
Right.
Because if it passes automatically to heirs, even though there might be an estate to probate, it's not the responsibility of the estate typically to take care of that. So we have some sort of mixed signals here, which can create some confusion. Meanwhile, of course, we have utilities that are now in the decedent's name, and no longer the responsibility of the estate frequently, and now the responsibility of the people that actually inherited the property. And if there's a mortgage, well, that's the debt of the decedent, and you may very well want to deal with that. A lot of times the lenders won't even talk to you. Right. So there's a bunch of sort of challenging issues there.
I think
that can arise.
What I'm hearing from you, Richard, is that there's several layers of complexity anytime there's real estate involved in a decedent's estate.
There is.
And I think, my recommendation to I guess our viewers today is kind of like, if there is real estate in the decedent's estate, it's probably a good idea to talk with the trust and estate lawyer about it, because there's a whole, circle of stuff that kind of comes along with that.
I think that's part of the initial probate consultation, though, is to kind of sort through those things, because if your property, I'm just going to summarize here, because if the property is located in, let's say, Fairfax County, and we're probating in a state of Fairfax County, it's all good. If it turns out the property is located outside of Fairfax, then we're going to have to do other work in those jurisdictions. But even more complicated, though, is if property, a lot of people have property down at the beach. They have property in North Carolina, South Carolina. They have mountain property, or they have, farm property. And as we've learned in a number of our shows of around the country that we've done, that we end up with ancillary, what they call ancillary probate, that can create a bunch of extra work, which is beyond the scope of this show, but something that we would want to identify in that probate consultation.
Sure.
Let's talk about tangible personal property. How does that get disposed of in an estate? Who owns all the dishes and the chairs and the tables and?
Right. So what is tangible personal property? So like you're saying, it's the dishes, chairs, all those household furnishings. It can be things like jewelry. Maybe if the decedent was a collector sometimes, like stamps or comic books or baseball cards.
Could be a car, I guess, too.
Yeah, or cars. Typically with cars, they have a title associated with ownership. Right. So those are slightly, could be grouped in, but also could be handled separately from the other tangible personal property we're talking about. But this kind of property, it's in the decedent's estate. It's a probate asset. So it's going to be something that has to go through probate.
Yeah, I would just make a caution that whatever you think that Hummel collection is worth, okay, that is part of this sort of tangible person property, it's not worth that much.
That's right.
Matt Quinn from Quinn's Auction has often talked to us about that when we've had him on the show. That is these tangible personal property typically is not worth as much as you think.
Right.
Well, what other assets we need to talk about, David, as we sort of working our way way through this particular initial consultation?
So a lot of people have life insurance. Does life insurance need to go through probate?
And that's another good question. A lot of times life insurance typically will have a beneficiary named, and a lot of times, depending upon the decedent situation, they may want to have a beneficiary named, because those proceeds payable to somebody outside of the estate is completely creditor free. Okay, so it can be very important in certain situations. But you have to take a look at the beneficiary form. So I think we have to figure out, what happens if there's no beneficiary. So tell me about that. What happens if there is no beneficiary named? Where does it go?
Yeah, and this happens more times than you would think, because either the beneficiary that was named on the form has passed away, has predeceased the holder of the life insurance policy, or they just never got around to it. Maybe they got the policy through employment, and it was kind of set up with them not really paying a lot of attention to it.
Sure.
And they never named a beneficiary. So in those circumstances, it'll go to whatever that insurance agency's kind of default is. And oftentimes the default is it will go to the estate of the decedent.
Okay. So I think how do we figure out, though, if someone's died and they don't have the policy information all collected in an organized fashion, how do we find out if they had insurance?
So I think a common place to start is, again, kind of going through the decedent's records. If you have access to their home, going through their file cabinet, you can look in the mail to see if a statement comes in. I mean, those don't come in very often for life insurance policies, but if you're lucky enough, you can catch kind of the yearly statement that might come in. You can actually look to see if there's premium payments being paid off of a bank account if you have access to bank records.
Okay.
Interestingly enough, there's even a database that can be accessed. So there's a database by the state insurance department. They have a policy locator, and you can use that to kind of see if anybody's ever taken out a policy.
Okay.
So that's a place you can start.
Okay. What about let's keep going on this. So I think we finished life insurance. A lot of people have retirement accounts.
Yes.
So, typical retirement accounts, 401ks, IRAs, and so on and so forth. And of course, retirement accounts are not an asset that you can actually, hold jointly with somebody. It's in your name alone if it's your account, or it's in your spouse's name alone. The way you do, though, is you can control that property, that account, through naming a beneficiary. So
that's correct.
who are the beneficiaries typically on these retirement accounts?
Well, if you're talking about a married person, typically they'll name their spouse as their
Sure.
primary beneficiary. And there's tax benefits to doing so. If the spouse inherits the retirement account and they choose to do so within 60 days, they can actually roll the account over into their own retirement account. They'll often name children, so you might have the spouse as the primary, and then maybe the children as secondary beneficiaries on the account. And again, like we talked about with life insurance policies, if you have a situation where the named beneficiaries have predeceased the decedent, or you didn't name anybody, then there's defaults. So some of the government plans, like a thrift savings plans, their defaults will actually be, the spouse, then children, if there's any children, and then to the estate. Some other places it'll just be straight to the estate.
So you need
in which case, then the proceeds all of a sudden become a probate asset.
Okay. And so, and that's really going to be a challenge, I think, to figure that out if it's not clear from the statements themselves, but you'll have to call and ask, and sometimes they'll tell you, sometimes they will not. I know there's some other things we want to talk about. We're getting a little short on time, but I know that there are business assets that people do have, for instance, LLCs and closely held corporations, and so, those are typically, either maybe controlled by contract as far as what you can do with those, okay? And so they may or may not need to go through probate depending upon how the certificate's set up. The one other asset I want to talk about real quickly is unclaimed property.
Yes.
What are we talking about there, David?
So, I mean, it could be literally anything, but I think typically what you're looking at is probably refunds. Maybe an overpayment was made to a utility company, or maybe there was an old bank account that was forgotten about, and at some point the bank, after losing touch with the owner, has closed the account, and they've paid this property over to the state treasury, saying that they've reached out, they've lost contact with the owner of the property, and so they want to wash their hands of it and do what they're supposed to do, so they transfer it over to the treasury. And the treasury has a website where you can go up and you can, I'd suggest anybody do it, frankly, because you might be surprised what you find, but you can put in your information or the decedent's information and find out if there's any unclaimed property on there.
Yeah, I will say that is that's probably one of the very first places you want to start, especially for older estates. I know we have recovered hundreds of thousands of dollars by making that inquiry. Yeah. And there are companies out there that are actually tasked by a publicly traded company to find people that shareholders they can't find anymore, and they will eventually find the heirs and then offer to help them go get the money that is sitting there in unclaimed property, but they'll charge you a pretty significant fee. So take advantage of that. It doesn't cost you anything other than a little bit of your time. So let's go to some pitfalls and recommendations as we proceed into our closing comments. Can you give me some sort of final thoughts, and pitfalls you think we should make sure people are aware of at this stage?
Sure. I think, we kind of brushed on a couple as we kind of quickly went through the various assets. But I think when we look at those assets that have the ability to avoid probate, typically through beneficiary designations, it's worthwhile to double check your beneficiary designations, because we see this all the time where maybe people have forgotten the youngest of 3 children or something like that, when by all means they would have wanted to name that child as a beneficiary on the account, or they just have never made a change. Maybe it names an ex-spouse. So you definitely want to double check your beneficiary designations on things like life insurance, retirement accounts.
Okay. I know from my perspective, I think, be very careful that we're clear and absolutely certain that an asset is only in the name of the decedent. And if you're not sure, just assume it does not until you find out otherwise. The reason I say that is that if you actually go ahead and decide to proceed to get qualified and get into the probate system, when you report an asset and say that there's an asset that's in the estate and it's worth $1 million, you just incurred a $1,000 probate tax. If it turns out that asset actually had a beneficiary designation or was somehow owned in a way that it would not have to go through probate, it's going to have a difficult time getting that $1,000 probate tax refund. So be careful about that. And then take a look at how your assets are titled. Make sure it is what how you intend them to be titled. If you're going to have will substitutes, which a lot of folks are enamored with, just be aware that those things can produce unintended consequences. So be sure the way you have it set up is the way you want it.
Yeah, I would say, Richard, piggybacking on what you just said, one that I see oftentimes, especially as people get older, is they'll maybe name a child on one of their bank accounts. And instead of maybe naming the child as somebody who can write checks from the account, like a signatory on the account, which is really the intention, right, to help them pay their bills, administer the account. Instead, what ends up happening is they put the child on jointly with them onto the account. And so when the person passes away, the unintended consequence is that joint owner is now the owner of that property.
Yeah, that can definitely be a problem. Well, I see that we are just about out of time, and someone is waving to me behind the camera that I need to wrap this up. David, I want to thank you for taking the time to visit with us. You know, shared a lot of great valuable information. Thanks for pulling some comments out for me as well. But this is all a great service to the Northern Virginia community. So thanks again for coming in today.
Appreciate it, Richard. Thank you.
Thank you. You know, collecting the assets, understanding how each is titled, and in the process discovering what the heck needs to be probated are necessary steps in the initial probate consultation. But identifying the assets to be probated is just the beginning of that consultation. Now we need to determine who inherits the probate assets. And this will be covered in our next show called Who Gets the Money, Honey? This brings us to the conclusion of our show. We hope you found it helpful. Until next time, take care, live wisely, and be safe out there.